It's a term used to describe either a same-sex or opposite-sex couple who live together, they're in a relationship but they're not married. A cohabitation agreement is a contract setting out the financial and other arrangements which the parties have agreed, both for when they're living together and in the event that the relationship breaks down. Generally they are, although it's rare for there to be litigation over them if they're well drafted. It's always advisable to have a separate declaration of trust in relation to property. And it's also a good idea to make a will to deal with arrangements after death. The law doesn't actually recognise common law marriage, so people who currently live together have no recognised legal status merely as a result of doing so. If they own property together, whether in joint or sole names, they have rights under property law. If they have children, they have all the usual rights and obligations that all parents have, which includes a right to financial provision for the children. They also have the right to apply for non-molestation orders and occupation orders where there's domestic abuse. And if they've been living together for at least 2 years before one dies and no provision is made in a will for the surviving cohabitant, he or she can apply for this under the Inheritance Act. This is something that can be covered in a cohabitation agreement, as it's important to know the parties' intentions. Sometimes these can be inferred from the parties' conduct in relation to the property. However, merely paying something towards the mortgage doesn't automatically give that party an interest, particularly if it's akin to rent. It's always necessary to look at all the arrangements between the parties, and the onus is on the party asserting an interest to produce evidence. Not automatically. However, the Children Act enables the party caring for the children to retain the property if the relationship breaks down and they need it as a home and it's not surplus to their needs. Alternatively, they can ask for sufficient of the proceeds of sale to enable them to rehouse with the children if required. Their own resources will be taken into account, and generally they will have the use of the property or the proceeds until the children reach the age of 18 or finish secondary education. Then any property will have to be sold and the monies repaid. Their rights to financial relief on a marriage breakdown don't depend on having children or establishing an interest in property. The law will take into account a range of factors including needs, resources, the length of the marriage including any premarital cohabitation, and the standard of living enjoyed during the marriage. The starting point is an equal division of the marital assets. There's more generous provision which can be made under the Inheritance Act, and there are various tax benefits and reliefs available including inheritance tax relief. If you'd like further information on any of these points, please don't hesitate to contact me. We can have an initial consultation and I'd be happy to expand on any of the areas discussed.